Okay, Ms. Dukes-McCoy, are you there? Can you hear me okay? Ms. Dukes-McCoy, are you able to hear me okay? Ms. Dukes-McCoy, are you able to hear me? Susie, are you able to hear me?
Yes, sir.
Ken? Okay, Ms. Dukes-McCoy, are you able to hear me? All right, I'm narrowing it down. It's not us. So let's see.
Hey there.
Hey, can you just call Ms. Dukes-McCoy's office and let her know that I'm gonna take the other 130 while they're reconnecting, and then I'll take their case as soon as I'm done with that.
I sure will.
Perfect, thank you.
Okay, thanks.
Bye.
Bye.
Good afternoon, Your Honor.
Okay, hello. Just making sure we get everybody connected here. it looks like Mr. Ryman's connected, but not turned on his audio or video yet, so if everybody could just wait for 1 second.
Is Peter's not connected yet?
Nope, I was waiting for Mr. Ryman. There, and he's connected now. Okay, great. All right, so we're gonna go on the record now. This is Ryman versus Johnston and Prather. This is case number 2319394. And if I can have everyone put your appearances on, starting with the plaintiff, please.
Good afternoon, Your Honor. May it please the court, Kevin Riemann in proper persona.
Peter Warden for the defendants Johnson, Your Honor, and my clients have joined the Zoom with us.
Ms. Stewart, you're muted.
I'm sorry, Your Honor. Jamie Stewart, appearing on behalf of the Johnstons also.
Thank you.
And then Dylan Jaskowski, Your Honor, appearing on behalf of the Prather defendants.
Okay, and Ms. Stewart or Mr. Worden, which one of you is going to be arguing this today on behalf of your client?
I will be, Your Honor.
Okay, great. Okay, thank you. We're all on the record here today. Defendant Johnston has filed a motion for security for costs. I did have a chance to review the motion and supplemental brief as well as the attachments to that. So Mr. Worden, was there any oral argument you wanted to present today in support of that motion?
Well, Your Honor, honestly, I don't like to file motions like this, but this seemed to be a fairly egregious situation, and I felt it warranted the motion. I'm aware that when this court says it's read something, it's read it, so I don't want to bore you with an unnecessary recitation of what I've already said in my brief. But it's obvious, even when you look at the more recent discovery responses from the plaintiff, that they really haven't gotten any evidence together to support their claims, despite having essentially an unlimited amount of time before they even filed the case last fall and during the several months since they filed the case. I've squinted as hard as I can and looked at plaintiff's pictures. I cannot find a ditch. I'm sorry, there isn't a ditch there. The state sent him an email stating that there is no permit required for my client's discharge from their crawl space to the lake. Plaintiff's discovery responses confirm he has no experts. This is a case, Your Honor, where the plaintiff is alleging that my clients made changes to the topography of the properties such that surface water now flows in a different way and has caused flood damage to his home. It's a case that absolutely needs experts to support those accusations. He has none. He's never indicated really why he thinks or has pled that the lake discharge from my client's crawl space is somehow contaminated. His discovery responses suggest maybe fecal material of some kind, but he's conceded he's had no testing done. And again, no experts. And this is going to be an expensive case, Your Honor, for my clients and their carrier to defend. We're stuck in a position where we've got to send experts out to the site to do their work and prepare the defense absolutely in a vacuum, and that's just not fair. And this seems to be the situation where the MCR 2.109 was designed to address. Therefore, we're going to renew our request that plaintiff be required to post bond for security for costs in the amount of $85,000.
All right, thank you. Mr. Ryman, I did not get a written response from you, but is there any oral argument you wanted to present in opposition of the motion?
Yes, thank you, Your Honor. I did not actually receive service of this motion under the court rule 2.119C. I did receive an email that contained it, although this is not an electronic service case and we had not previously agreed to service by email. I did overlook it initially, but in preparing my discovery responses about a week ago, I came across it. And then Dylan Jaskowski asked that he be provided a copy with it, and that renewed my familiarity with it. And then again, without the court having indicated an allowance of the supplemental brief and in violation of the court rule on that, counsel filed a supplemental brief, and I did contact Mr. Warden at that time and said, look, if you want me to address those issues, I think you should adjourn it until your next hearing date. And I didn't hear back from him, so I am prepared as best as I can to reply to those issues raised in his brief and his supplemental brief today. Your Honor, I can see why Mr. Warden doesn't normally like to file motions like this. It is completely unfounded. It's disingenuous. It is frivolous. And unfortunately, since I'm in pro per and there are no costs associated with it, there's no sanction for Mr. Warden bringing a motion like this. But I'd like to look at what he has claimed to have supported by way of his motion and attachments. And, you know, off the top, we can see that one is sort of a tabloid internet inadmissible article. One is an email, purported email to Mr. Johnson without the original email or any context, without an affidavit, and that would be inadmissible. And then there is the, you know, confidential protected communication from me to defense counsel by way of email. And that is, as the court knows, inadmissible by the Michigan Rules of Evidence. And of course, it's labeled confidential and protected settlement discussions. And certainly there'd be a chilling effect if the Michigan Rules of Evidence in regard to that were ignored. But I will address the contents because here we are. Mr. Warden has included it and court's indicated it's read it. The essential point apparently Mr. Warden is making is that he did attach an affidavit of the defendant, Scott Johnston, which stated that the pictures in the brief, and I guess I didn't look to see if it would encompass the supplemental brief, but that the pictures are accurate depiction of the condition of the property when he purchased it. And I would wholeheartedly agree. I honestly, I cannot believe Mr. Warden is presenting to the court those pictures and saying, and this is the first one, and you can see I've circled down here the boulders, the stone boulders that are covered mostly by the leaves. But this entire area here is the ditch we're talking about. If he doesn't like the term ditch, we can use channel. But the definition by Webster of a ditch is a channel built and or designed to direct and keep away water from the roadway, from adjoining property. That's exactly what it is. And it's not as though I haven't provided him with evidence that exists. I have given him discovery photographs that show it a little bit better than his pictures. But unfortunately, Your Honor, this is an area of both properties that just isn't photographed very much. So they're not very good, but I have just blown up counsel. See if I can show it. This is counsel.
Well, maybe if you could just refer to the exhibit, because I'm not going to be able to see what you're holding up there.
Okay. Yeah, it's his photographic exhibit attached to his original brief. I'm not sure if it's A or B, but it's unfortunate that you can't see the close-up because it shows the huge boulders. In the photograph you're looking at, Your Honor, it would be sort of the left middle. And if you squint under, you can see there's a gap in the leaves. That entire area of leaves there, about 3 foot to 4 foot wide, going down the left side of my driveway. That was built to prevent what's happening now, and that was covered up by what Mr. Johnson calls his landscaping. I would refer to the court to his affidavit. That's supposedly the support for finding that this stone ditch didn't exist and was never covered up. You'll note that Mr. Johnson never states in his affidavit that that stone ditch channel, whatever water runway, as I claim, did not exist. He doesn't say that. And he doesn't say he didn't cover it up. He simply says the topography, he says he did landscaping only. And my complaint was verified with an affidavit that is evidentiary and I did support with my claims in that the stone ditch was built by Matt Kabliska in 2005. Mr. Kabliska's contact information and expected testimony was given in discovery to the defendants. Mr. Kabliska does not have internet articles against him. He is a super lawyer, one of the preeminent lawyers down in Oakland County that is very familiar to at least defense counsel Marielle Lehman. They're very familiar. They were neighbors for many years, and all they have to do is get a statement from him. If that's not enough, Your Honor, I provided the names of about a dozen other neighbors, all of whom will testify that they saw Mr. Johnson drive his tractor onto my property with I don't know if you call it a plow or a disc or a rake, and tear up what you see here in the photographs provided by counsel. There's one photograph that shows this, and then there's one that shows a picture a little more to the left, and I'm getting like reflective feedback, so I'm not sure what the court can see, but just past this ditch, there's some brown material in the exhibit. Those aren't leaves. There's no trees over there. Those were wildflowers that had died because it was fall. It was October. And those were all disked up. And you don't have to take my word for it, Your Honor. You can see in the pictures that were attached to counsel's supplemental brief. And if you look at those, they're all green, they're grass. And that stone area, that stone ditch is gone. So they might be playing a wordsmith game to say the topography hasn't changed the elevation, because the highest point on his lot in the picture is all he says is not changed. And that may be true, but what the question is, did he fill in the ditch, preventing the runoff from flowing down into a catch basin, which was built in conjunction with that in 2005? And the results, Your Honor, this is to put some sort of, I don't know if you can see, again, too bad we're doing this on Zoom, but this is the result. The ditch no longer carries the water away, and it comes into my house. And I have disclosed the photograph showing that. The last event was that I showed by Discovery Responses was in October of 2023. There's no serious question or issue that Mr. Johnson plowed over the ditch. And as a result, for the first time in history, at least in the 30 years that I've testified in my complaint that I've been going to this property, for the first time, not only is there a water runoff issue, but it comes right into my home and buries my furniture, my carpeting, my pet products, everything in my house up to 4 or 5 inches. Now that I know that it's happening, I make sure that I'm present, and I go out all bundled up, whether it's lightning or otherwise, and I battle to keep the water out of my home effectively so far. So far. And this all came to a head because, and I've again submitted this to counsel, Mr. Johnson insisted that he was going to not only refuse to restore the stone ditch that he took out or covered. It's still there. You can see it if you go to the site. I've invited counsel. You can see the stones underneath, and all you have to do is shovel off some of the boulders. But he declared he was surveying it and posted it, and you can see the survey in the supplemental brief attachments to counsel's brief. He was going to put a circular drive in there, and it just brought things to head. If he had done that or attempted to do that, if the water issues could have gotten any worse, they would have. There's no place for this water to drain. He's essentially taken that ditch, which is covered in leaves in the photographs, but other than that, it perfectly shows the ditch. It's just covered in leaves. He covered that up, and it's gone. And not only that, Your Honor, and again, if we could see this better, unfortunately with the Zoom you can't. You can see the watermarks in counsel's pictures, which show any overflow that came onto my driveway were directed off to the south, which is where the catch basin was. Now, and it's no secret, as I stated in my complaint, which was affirmed with an affidavit, Mr. Johnson acknowledged this. There's at least a half a dozen to a dozen neighbors that came over and witnessed the exchange. He said that he didn't like that the water coming off the road in major events caused sand to come down from the road through the channel and into the catch basin, which is true. And I'll acknowledge the ditch that I'm talking about was more prominent and appeared a little bit differently when it was built in 2005. Sand is now carried off and gravel from the roadway, and it's kind of filled it in. But you can still see the big boulders. And theirs are huge, a foot around, and you can see in the photograph, Your Honor, that my driveway is higher than that ditch area, which directed everything into it. That wasn't just done gratuitously. Although the prior owner of that property was a good friend of mine, attorney Matt Kabliska, and had just sold me his place when he moved next door. But he was required, the legal standard, and nobody's contested this, is he can't make change, an adjoining property owner can't make changes that alter and increase the surface flow of water onto onto the neighboring property. So in 2005, Mr. Kabliska and his then wife hired an excavator and architects, and they built an addition to the front and back of the home. They took what was a dirt driveway with a dirt floor, small detached garage, and they added a double driveway and a two-car garage that was all paved and complete pavement leaving from the road across the whole property to the property that adjoins, my house. So in order to ensure that that change, they're much more than that. He built a septic field up on the road. All of this directed surface water towards my property. But this intervening channel or stone area, which was lower than both properties, directed any water that came off the road or any water that came off defendant's property into that channel and down into the catch basin. There was never, ever an issue. And you can see that in the photographs. I wish you could see it better, and I wish there existed better pictures of that area. I do know that defendants had inspections for their mortgage and insurance, and I'm sure those photographs would be much better, but they haven't been provided. But I don't have any better pictures because it's just not I do have a little better pictures that I provided to defendants, but Your Honor, they're like putting their hands in front of their eyes and pretending they disappear, like a clown with a baby. It's not just because you cover it and show it from a distance doesn't mean that area isn't the ditch or the channel, however you want to call it. In addition, Your Honor, to providing numerous witnesses that will corroborate my testimony as expressed in my affidavit attached to my complaint, there's nobody that I'm aware of that will say otherwise. Defendant Johnston didn't say otherwise in his affidavit. He didn't say there was not a stone channel there. He didn't say he didn't cover it up. And in fact, the pictures that he added to his supplemental brief clearly show he did. Planted grass over the whole property and mine. If you look at the pictures on his initial brief and the pictures on his supplemental brief, you can see that he planted grass all over my property as well. So there's no serious contest. And as I also stated in my discovery responses provided to counsel, attorney Mariel Lehman, who's appeared as a defense attorney in this case, her husband Brett is the person, and I named him in my initial disclosures and statements, came over and cleared those leaves off. The leaves that you're seeing in the attachment to the brief, what I'm saying is the stone ditch. he brought a hand torch over and helped me burn those off because it's hard to rake the leaves out of the stumps. They fall in and they get caught. And so I would usually spend, a day in the spring and a day in the fall burning that area. And Mr. Lehman would come over when he was around and we'd just chat and he would burn it off with a hand torch. There's no person that's going to say otherwise. And as I said, defendant didn't say otherwise in his affidavit. He only wanted to call it landscaping and said the elevation change wasn't altered in the picture. Do you have any questions about the stone ditch, Your Honor?
No, I don't.
Okay. I want to talk for a minute about the email from allegedly from Claire Lowe at EGLE. First, she says she's responding for Mr. Johnston's request for guidance in August of 2023, but we don't see the initial request for guidance, and we're not provided any evidence of that in Mr. Johnston's affidavit. But if you look what she says, she adds claims, an additional support for my claims to my complaint. In paragraph 47 of my complaint, I reference the same act, the same statute that is discussed in that email, but they're skipping over the part of the statute that refers to surface water. Surface water is covered in section 303 as alleged in my complaint, and it controls any property within 500 feet of an inland lake, such as Little Bear Lake. And as alleged in my complaint, it precludes altering 25 square feet or more that affect the distribution of surface water. If Mr. Johnston wants to call it landscaping, it doesn't matter. He took the whole property, hundreds of square feet. In fact, the channel itself is more than 25 square feet. And the statute requires section 303. They're referring to section 1309. I'll get to that, but section 303 requires that to be permitted. And in my complaint and in my initial disclosures and in my discovery responses, I identified Patricia Osborne as the person who will testify that that change needs to be permitted and would not have been granted and was not granted. They've never talked to her. Also in my complaint, I've alleged in paragraph 59 that the same statute, the water, the wetland DNR statute at part 404 precludes the flow of contaminants, let's call it contaminants, into the waterway and use of a bubble system without an EGLE permit. And that isn't even contested. They're saying, well, he hasn't tested the contaminants. So, Your Honor, in response to that, I did in my initial disclosures and in my discovery give him the name and address and telephone number of the neighbor who did the fecal testing and attributed it to defendants' dumping of water into that. Now, it doesn't have to be fecal matter. Under the statute that they put forward, section 3109 of the Act says that a person, this has nothing, it's not meant for surface water, as I said, but let's read it for what it says. A person shall not directly or indirectly discharge into the waters of the state a substance that is or may become injurious to, and if I go down to C, to the value or utility of riparian lands. That means lands adjoining an inland lake, amongst other things. That is a very specific allegation that I made in my complaint, Your Honor. It's almost as if I looked up the relevant facts and law in drafting my complaint, because I did. I've alleged and supported by my affidavit, and it's been uncontested, that as a result of dumping this water, whatever you want to call it, into the lake, which started with Mr. Johnston's ownership, which resulted from an unlicensed, unpermitted, underground extension of a flow of water out of his crawl space. He and a buddy dug out and built into the water. Now they cover it up with kayaks, but they dump the water directly out in the water and into the lake. And for the first time ever, I've only been there 30 years, but I've presented witnesses in my initial disclosures and discovery responses that will say for 80 years. There's never been any algae growth or any muck such as accumulates around this dumping of water by defendant Johnston's into the lake. So how did he respond to that? He built an unpermitted, unlicensed, unlawful electric post, which he did with, I believe, the same buddy, and then they plugged into that post out near the water an electric bubbler system that they then put out in the water where all the algae and muck was growing to dissipate that. They've never alleged in their motion or anywhere that that's not true. They only say that that bubbler system helps clean up the water, which may be true. But the whole point of it is it's not allowed without an EGLE permit, as cited in my complaint. And then the reason they don't get that permit is they would never be allowed that permit because Eagle would come out and say, well, you can't dump this water in here in the first place, causing the problem, much less putting this electrical system out into the water. So after I filed my complaint, again, as disclosed in my initial disclosures and my discovery responses, defense attorney Marielle Lehman's husband, Brett, snuck out and dragged it all in and stuck it under a tree. And again, nobody has denied that.
Are you done now?
I'm sorry, you had a question, Your Honor?
Who just said that?
Okay, on the
Wait, who just said, are you done now?
This is Scott Johnson. I didn't know if he was done or not.
Mr. Johnston, your attorneys are here to speak for you today, so.
Okay. Okay. Thank you,
just
sir.
a final note on the Eagle email, Your Honor, is that here's what she states about it. While we strongly recommend discharging crawl space or basement sump pumps to the ground, there is no specific prohibition against surface water discharge if the water is only groundwater seepage under section 3019. Again, under section 303, there's an explicit prohibition about that. And she's even stating there, we strongly discourage it, even if it's not within a wetland. And the reason is obvious. And the reason is why it was set up. This is kind of interesting. The person who originally built the discharge system, as alleged in my complaint and my answers to discovery, was the other defendant in the case, defendant Prather. But he at least discharged it about 40 feet from the lake into the sand. So the water could dissipate and any contaminants, whether it's fecal matter or fertilizer from the grass maintenance or whatever, that could dissipate before it got to the lake and before it got down into the groundwater. That's the very reason for it. So even if there was no other section, Eagle strongly discourages it. And I submitted in my complaint, in my affidavit in support, my testimony that the water was beautiful and crystal clear when the Johnstons bought the property, and when they started discharging that water into it, or from under their house, it got all mucky and algae. And I submitted at least a half a dozen of witnesses who will say the same thing, including defense attorney Mary Lehman's husband, Brett, who complained to me of it as I was preparing to file the complaint. And they've never produced any witness who will say otherwise, including Mr. Johnston. He did not state in his affidavit that discharging the water into the lake was not, as I alleged, something that diminished the utility and value of my, to use the language from the statute, riparian lands, to use this language from my complaint. It made it less enjoyable to use the water, and we couldn't go out and swim in it and walk into the area right off the shore because it was full of muck and algae. So that's all I have on that issue, Your Honor. And if you don't have any questions on that, I would just finally refer to the issue raised in the supplemental brief.
Okay, no, I don't have any questions.
Okay. The issue raised in the supplemental brief is that plaintiff has failed somehow to make a statement of what was damaged or any value claim. And as you can see from his attachment to that supplemental brief, he attached my answer to interrogatory 2A, where I itemized the list of things. For example, I don't have it right in front of me, but one of them was all the carpet in my house was sat in inches of water for about 3 or 4 days until I got there. And at that point, it was not salvageable. So all the carpet and all the padding was torn out. And then I supported not with just a specific claim, but also with photographs, how the interior walls were damaged 4 or 5 inches up from the floor. My entire cottage is knotty pine. And I gave him my estimates received for repairs. Now he wants to challenge that and say, well, you got to hire an expert. If he disagrees with it, I've invited him to, and it's an open invitation, bring an expert or bring somebody to contest those to my house. It's all still there. Most of the damaged furniture, which I've itemized with specific values in the answer to interrogatory 2A, is still there. And he's welcome. Part of the problem of being any more specific is some of it was purchased from a place called Art Van. I don't know if that's something you had where you are, but it's closed down here. And so you can't just go and say, well, how much is that today? But I've given the estimates on the same product and I've provided photographs. Some was purchased at an upscale family business here in our area called Art Sample, I think it was. That was another of them, but they just don't exist anymore. So you have to do the best you can with the photographs and then comparing it to other products. So I gave him as specific as I could, and they haven't provided anything to show that's not correct or accurate, much less that it's made up and I should be sanctioned with a bond, Your Honor. As you know, that's an extremely unusual, rare request. It's certainly unfounded and unwarranted and would have a chilling effect on plaintiffs. If you brought a case where you had to spend your own money to bring the case, if the insurance who was responsible for the issue said, Judge, we got to hire expensive experts. I would, in terms of what he is claiming they need an expert for, Judge, I don't believe I have to hire an expert to prove and convey to a jury that excrement, literally in this case, flows downhill. And surface water flows downhill. And if they don't want to take my word for it, I have photograph and I've provided it to counsel. It shows if a river is too strong, certainly a creek is not too strong. And Mr. Warden at least acknowledged in his supplemental brief, yeah, the situation probably exists. So the situation exists. It never existed before. There's no evidence it existed before. And he highlights the problem that I explained to him is that my security cameras, which collected video of Mr. Johnson over several days on my property, doing the damage I alleged, and over at least a week more on his own property, dumping topsoil, changing everything, covering the ditch. Mr. Johnson had agreed to correct that when we realized it was directing the flow into my yard. It was a problem. And it was more than a year.
Brandon, I'm gonna cut you off because you're starting to repeat yourself.
Okay.
And this is the motion regarding security for costs. So if you have any more to say that directly bears on that question, I don't need any more background.
No, Your Honor, I'll just conclude, and I appreciate your input in that regard. Is it's a straightforward case. The picture shows the ditch I'm talking about. All the witnesses that I provided support it. The question is really, how much damage did it cause? And for that, I've expressed that to them, and they're welcome to come and have an adjuster look at it. The only thing I didn't address, I just realized, Your Honor, is the claim that this is somehow insurance fraud. This is an insurance case. When somebody causes damage to your property because of negligence, that case is to be submitted to your homeowner's insurance. There's nothing improper if the homeowner's insurance refuses to at least defend you, and that subjects you to a judgment or potential judgment. There's nothing wrong, and it's routine in negotiating an assignment of that claim to secure everybody's position. To show that there was no issue of fraud, you can see in the improperly submitted evidence that I insisted that the Johnsons put in $20,000 of their own money without any opportunity to recover that, so that they had some skin in the game. And the way assignment of insurance claims work, Your Honor, is that I would have still had to prove to recover on that claim that the insurance applied and that the damages were caused as I alleged. That's a great way to resolve it, to protect both parties and take the Johnstons out of. They would have no more risk above 20,000 if I collected on the case. So, and you could see, I don't know if it's in there, I haven't read it, but there's no place I refer to anything but let's just tell the truth. It's a simple matter. Let's tell what happened. And the second purpose of that, and the reason this shouldn't be admitted and shouldn't be referred to like this is, Judge, there's other reasons you submit settlement discussions like that. In this case, it worked perfectly because Ms. Lehman had to discuss with the Johnstons how property insurance for claims like this works. And the next thing you know, it was submitted and the insurance agreed to come in and provide a defense. So that's all I have. Thank you.
All right, thank you, Mr. Worden. It's your motion. Anything in response?
Very briefly, Your Honor, I do want to direct the court's attention to the proof of service, which was affixed to our original filing. It indicates my assistant did serve this on Mr. Riemann, both by email and also by placing it in U.S. mail, which is also, as it happens, our standard operating procedure in counties such as Otsego, which don't utilize the electronic filing. So I think we've submitted adequate proof that he would have received this. I don't understand why we didn't get a written response. I'm trying, Your Honor, to just, after listening to all that, really trying to understand, but I've tried to file a very simple motion. He's alleged that there was a ditch. He's alleged that my clients changed that ditch. We provided evidence through photographs, which he's conceded showed the area prior to my clients moving in. He's conceded that those photographs accurately depict the area before my clients moved in and made any changes at all to their landscaping, and there simply is no ditch. And I'm a little befuddled by this because he keeps saying that there's something there. The court can obviously look at the pictures, both that are attached to my original motion and to my supplemental brief. The supplemental brief photos were provided to me by Mr. Riemann. These are pictures that he claims show the ditch. I've squinted as hard as I can. The court can make its own determination, obviously, but there's no ditch. And in fact, if you compare the pictures he's provided to more recent pictures, as I pointed out in the supplemental brief, there really doesn't seem to be any change to the area. It looks the same. So, there was a lot of, I have witnesses that are going to say this, I have witnesses that are going to say that, but the photographs seem to indicate that there's no there. So this is, I think, an appropriate case for security for cost. And yes, given what the photographs clearly tell us, I think he does need experts of some kind to explain how surface water has changed. And I think he does need an expert of some kind to explain why and how this discharge from the crawl space is supposedly contaminating the lake. He says it's out there. He says he knows of somebody who knows of an expert who's done the testing. He's had several months to collect that evidence. Why has he not submitted it? That's all I have, Your Honor,
okay.
Unless the court has any questions.
I do not, thank you. All right,
Your Honor,
so, no, I think both sides have had adequate opportunity to present oral argument here today. So the court's looking at MCR 2.109, which is the court rule cited by the defendants in seeking relief here. And what they're asking for, again, is for the court to require security from the plaintiff in order to proceed with the case. And I think both sides have accurately referred to MCR 2.109, both in writing in the case of the defendant and Mr. Riemann here on the record, that question is a matter that's within the discretion of the court, and it requires the court to find a substantial reason. And a substantial reason for requiring security may exist where there's tenuous legal theory of liability, or where there's good reason to believe that a party's allegations are groundless and unwarranted. And that's the basis that the defendants are asking the court to impose security here in this case. There's no particular time frame in which a party has to seek a motion for security. However, typically it should happen in the early stages of the case, so the court finds that in terms of that kind of timeliness, that the motion was timely here. In terms of a hearing, the court, again, is largely up to the court's discretion in how to conduct a hearing on a motion for cost. It's not required to conduct an evidentiary hearing. And the court can even take into account the judge's own experience through court proceedings in determining whether or not a bond or security is required. Looking at all the circumstances here, first of all, I mean, while some of the exhibits submitted by the defendant in support of their motion may not be admissible in some proceedings, there's nothing in the court rule that prevents the court from taking those types of things into consideration when considering a motion for bond. And the other thing that I would say is, similar to a motion for a preliminary injunction, when parties are arguing, the element or the factor of whether or not a party is ultimately going to succeed on the merits, motions like this, as motions for preliminary injunction sometimes go, it kind of turns into a motion for summary disposition type hearing, where both parties are kind of arguing for or against summary disposition in the context of really what is just kind of a preliminary motion for whether or not security should be imposed here. So I stress that to say that the court's not making any determinations about the ultimate propriety of the plaintiff's claims or the defendant's defenses in this case. I'm strictly looking at this and a lot of the arguments made by counsel and Mr. Ryman today only in the context of whether or not it justifies the imposition of security. And again, I think ultimately what the court has to find is a substantial reason. And when it comes to allegations being groundless or unwarranted or tenuous theories of liability, I think that's more than just the court saying, well, I don't think the plaintiff could survive a motion for summary disposition, or I don't think the defendant could bring a successful motion for summary disposition. I think it's got to be more than that. I think it has to be, a level of tenuousness or groundlessness beyond just what would justify the granting of a motion for summary disposition. And in looking at what the defendant submitted, I think maybe they do have some good arguments for summary disposition, and maybe they don't. If both sides fully present documentary evidence under 2.116 C10 or even C8, and the court considers all of that, but that's a whole different consideration. And I think what the court ends up with here is the defendants are kind of saying that the court has to find that there's so few facts or so little evidence to support the plaintiff's claims that security would be warranted, but yet in order to bring a motion for summary disposition, they would be required to expend a bunch of money on experts and everything else. And to me, those things don't kind of square. If it's so warrantless and so ungrounded and so unsupported by any kind of evidence or facts, then it should make motion for summary disposition from the defense relatively simple and cost effective to bring, which then kind of defeats their request for cost. So I don't find, in looking at the circumstances as a whole, that the unusual remedy of requiring security up front is warranted. I don't think the court can find that there's a substantial reason, given the record that it has in front of it now, for requiring security. Now, of course, if the defense is fully free to bring motions for attorney fees and costs if they're the prevailing party on a motion, or ultimately, I think if at some point the defense may be even justified in requesting security going forward if this matter is going to go to trial. I don't know. I mean, I have no idea how things are going to go, but I could say at this point, I don't think that there's a substantial reason to require security. And I think to the extent that any of plaintiff's claims are dismissed or found to be groundless or unwarranted later, I think the defendants have an adequate remedy in seeking costs or fees at that time, and that there aren't substantial grounds for requiring the plaintiff to put up money up front. So for all those reasons, the court finds that the standard under 2.109 has not been met this time, and the court will deny the motion. And Mr. Worden, that court would just request that you submit an order reflecting the ruling and just indicating for the reasons stated on the record, and submit that under the 7-day rule.
I will do so, Your Honor. Thank you.
Okay, thank you. I have to move on to my next hearing. So that's all I have for today. All parties in this case are free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Yes.
Okay, Ms. Stutz-McCoy, are you able to hear me?
Yes, Judge, can you hear us?
I am. Thank you. And I apologize for that. I didn't think that other hearing was going to take that long. So I appreciate your patience and that of your clients. And but we are ready to proceed on your file today. And that is, I believe, entry of a judgment of divorce. Is that correct?
That is correct.
Okay. Was there anything that you needed to state for the record beforehand, or do you just want me to swear in Mr. and Ms. Washburn?
I think we can go ahead on proofs, Your Honor.
Okay, Mr. and Ms. Washburn, if you both would raise your right hand, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Ms. Washburn, your answer didn't come through.
Yes, Your Honor.
Okay, thank you. You can both lower your hands, and Ms. Stutz-McCoy, please proceed.
All right, thank you. I'll begin with Ms. Washburn. Kristen, could you please state your full name for the record?
My name is Kristen Marie Washburn.
Okay. And you are the plaintiff in the divorce proceeding?
Yes.
Okay. And you filed your complaint for divorce on December 11th of 2023, is that correct?
That is correct.
And were you and Mr. Washburn residents of the state of Michigan for at least 180 days before you filed for divorce?
Yes.
And were you both residents of Otsego County for at least 10 days before you filed for divorce?
Yes.
And your spouse is named David Washburn, correct?
Yes.
And you and he were married on October 15th of 2019?
Yes.
And you were married in Boyne City, Michigan, is that correct?
That is correct.
And you were married by a person licensed to perform marriages?
Yes.
Okay. And your maiden name was Kristen Marie Richter, is that correct?
That is correct.
And are you asking the court to restore your last name to Richter?
Yes, please.
And that is Richter?
Yes.
Okay, thank you. And you and Mr. Richter Mr. Washburn have no children together, is that correct?
That is correct.
To your knowledge and belief, are you currently pregnant?
No.
Okay. Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
It is not going to be restored. No.
Okay. All right. Thank you. Do you believe there's any chance for reconciliation?
No.
Okay. You and your spouse made agreements, created your proposed judgment of divorce, and presented that to the court. Is that correct?
Yes.
All right. And in that judgment, you agreed to a certain division of property, correct?
Yes,
So in short, you will keep your house, which you had before the marriage. Is that correct?
yes,
Yes, okay, and your dogs.
yes,
And each of you will receive your respective vehicles. And,
yes,
and your bank accounts
yes,
and your personal property.
yes,
Okay, thank you. Do you believe that the agreement that you made regarding property is fair and equitable?
yes,
Okay. Are you going to receive any spousal support?
no,
Okay. Do you understand that spousal support is forever barred and you won't be able to return to the court to request that in the future?
yes, I understand.
Okay. Are you asking the court to enter your judgment of divorce today?
Yes, please.
All right. I don't have any further questions for Ms. Washburn, Your Honor.
All right, thank you. Did you have any questions of Mr. Washburn?
I can ask him some questions, Your Honor.
Okay.
So, all right. So similar questions, Mr. Washburn. Please state your name for the record.
David Walter Washburn.
Okay. And did you hear all of Ms. Washburn's testimony today?
Yes, ma'am.
Do you have any reason to disagree with any of the answers that she gave?
No, ma'am.
Okay. And you and she made a proposed judgment of divorce together and you signed that and presented it to the court, correct?
Yes, ma'am.
Do you believe that the settlement within is fair and equitable?
Yes, ma'am.
Okay. And you understand that as of today, as it concerns spousal support, you're not going to be receiving spousal support either.
Yes, ma'am.
Okay. And you understand that you won't be able to come back to the court and ask for the court to pay that or have you pay that in the future?
Yes.
Okay. All right. So are you asking the court to enter that proposed judgment of divorce as well?
Yes, ma'am.
Okay. I don't have further questions for Mr. Washburn, Your Honor.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. I reviewed the proposed judgment. The court will grant the divorce. I've signed that with today's date. Ms. Dutz-McCoy, anything else that we need to address for the record today?
Oh, thank you very much, Your Honor.
Okay, thank you. That's all for today. You're free to disconnect at this time.
Thank you.
Right, that concludes the court's afternoon docket. The court will be in recess until 9 a.m. tomorrow.